16 नंबर में आ नहीं पाया था, मेरा प्रेजेंस मार्क कर दिया मेरा रिस्पॉन्डेंट के लिए हूँ मैं। गवर्नमेंट का अपील था उसमें, पिटिशनर्स मतलब रिट पिटिशनर जो थे, आइटम नंबर 16 में।
आपका वकालतनामा है उसमें?
हाँ इसमें मैंने,
अच्छा, विल चेक अप एंड
ठीक है मैडम, उसमें पिटिशनर के लिए सारी गवर्नमेंट तरफ से रिट अपील है।
उसमें आप आए थे?
यस माय लॉर्ड, मैं वो उपस्थित नहीं हो पाया था मैंने उस समय, लेकिन मैं चाहता हूँ प्रेजेंस मेरे मार्क कर दिया जाए मैंने।
स्टेट नहीं, स्टेट
स्टेट का अपील है माय लॉर्ड, मैं
स्टेट की तरफ से तो अपेयर हुए थे कोई?
नहीं नहीं माय
हाँ,
लॉर्ड, स्टेट
स्टेट की
का
तरफ।
अपील है। मैं जो रिट पिटिशनर थे वहाँ पर रेस्पॉन्डेंट है माय लॉर्ड।
हाँ,
रिट पिटिशनर यहाँ पर रेस्पॉन्डेंट है, मैं उसके लिए रेस्पॉन्डेंट के लिए हूँ।
तो आपकी जरूरत ही नहीं है, उनका केस डिसमिस हो रहा है।
मैं
आपके असिस्टेंस की जरूरत ही नहीं है।
नहीं, मैं कह रहा हूँ मैंने प्रेजेंस मार्क कर दिया,
प्रेजेंस में भी मार्क,
प्रेजेंस में भी मार्क मैंने।
पावर नहीं है आपका?
मेरा पावर है, मेरा रिट पिटिशन में लगा हुआ है।
आप ही हो ना?
हाँ
ये WA में नहीं है, WA सुना है हमने, WP नहीं सुना है। सिर्फ WA में आपका पावर नहीं है।
मेरा जब उसमें रहता है तो ठीक है, मैं चाहता
नहीं नहीं, वो तो अलग केस है।
काल इसमें रिफ्लेक्ट हो रहा है इसमें।
WP एंड WA आर डिफरेंट केसेस।
WA's name is reflecting.
नो,
नाम
बट
मेरा
देयर इज नो वकालतनामा।
Alright.
वकालतनामा होगा तो देख लेंगे।
Yes, yes, ma'am.
मेरा वकालतनामा में रिट पिटिशन में है मेरा, और
नहीं
जो
नहीं, तब
रिकॉर्ड आया
WA में नहीं मार्क होगा आपकी
और
अटेंडेंस।
वो मेरे को कॉपी भी सप्लाई की, तो काल इसमें मेरा नाम भी रिफ्लेक्ट हो रहा है उसमें से।
अब वो क्योंकि सप्लाई हो गया
इसके पहले मैं उपस्थित भी हुआ था मेरे।
वकालतनामा होगा तो मार्क करेंगे, अदरवाइज नहीं। यस।
My lord. My lord, I'm appearing in 3 cases. 37.12, my lord, have noted down yesterday, but again, my lord, I'm giving the numbers. 37.12, Vipin Kumar Tripathi, WP number 4303 of 2020. 37.23, WP 8930 of 2020, Swatantra Kumar Jain. 37.43, Dr. Kedar Kumar Mishra, WP number 23252 of 2021.
यस सर।
Malab, these cases are essentially related to the appointment with the government services, Malab, with respect to the government services, Malab. Malab, may kindly have the paper book of WP number 8930 of 2020, 37.2.
You have also challenged the vires of that act.
We have challenged the bodies of that act. Just one thing which is additional to the other petitions, Malab. Because these petitions are pertaining to the appointment in government service and reservation in government services, we have also challenged the consequent amendment in rules of 1998, which amended the roster, 100-point roster, by giving them reservation up to 27%. Just one document.
That is a consequence.
Consequence.
If the foundation goes, the consequence also goes. We don't have to separately mention it.
I just wanted to bring it to my
Or if it is upheld, it is upheld.
I just wanted to bring it to my notice that the impugned roster is also challenged, the new roster, my lord.
No, that is not relevant.
My lord. In this case, my lord, what had happened, the vacancy.
The points that have been argued, besides that, anything extra?
My lord, I'm directly coming, I'm skipping all the facts of my case, my lord. I'm directly coming to the legal arguments, my lord, in this case. My lord, as far as the reservation and the extent of reservation is concerned, my lord, the Constitution does not provide for the extent of reservation. It only provides for the 16.4, which talks about the reservation. My lord, may kindly have 16.4.
Yes.
May I read, my lord?
Just a minute. (16.4), yes.
My lord, nothing in this article shall prevent the state from making any provision for the reservation of appointment on the post in favor of any backward class of citizen, which in the opinion of a state is not adequately represented in the services under the state. So the requirement is which in the opinion of a state is not adequately represented in the service of a state, my lord. So reservation provided in the services, my lord, is governed, is flow from 16.4, my lord. Now, my lord, in this regard, my lord, the first judgment is Balaji, my lord. I'm referring to Balaji's judgment. I will not repeat the judgment which are already cited, my lord. M. Nagaraj and Maratha Reservation. They are, my lord, have gone through each and every paragraph, so I will not repeat those judgments, my lord. I just wanted to refer Balaji, my lord, 1963, AIR 1963, SC 649. This is the first judgment, my lord.
649.
649.
Hmm.
This is the first judgment of the Constitutional Bench,
AIR.
AIR 1963,
Hmm.
SC 649,
Hmm.
MR Balaji versus State of Mysore, my lord.
Yes.
My lord, this is the first judgment which talks about the limit of reservation
Hmm.
after the independence. my lord.
50%.
It talks about the 50%.
That was for the first time.
For the very first time,
First
Supreme Court has dealt the
Okay.
issue of extent of reservation, my lord. I'll just read two paragraphs, my lord. The paragraph number 8, which is the fact of the case. On 31/7/1962, the state passed the impugned order, which supersedes all the previous order made by the state under Article 15(4) for reservation of the seats in favor of scheduled caste and scheduled tribe as well as backward classes. Under this order, the backward classes are divided into two categories: backward classes and more backward classes. The effect of this order is that it has fixed 50% as a quota for reservation of seats for other backward classes. 28% out of this is reserved for backward classes, so-called, and 22 for more backward classes. The reservation for 15% and 3% for the scheduled caste and scheduled tribe respectively continues to be the same. The result of this order is that 68% of seats available for the admission to the engineering medical colleges and to the other technical institution specified in the order passed on 10/7/1961 is reserved, and only 32% is available on merit pool. This is paragraph 8, my lord. I'm reading from the SCC version.
Hmm.
Paragraph 8 of the order. Now, my lord, in this case also, the Supreme Court has dealt in detail with respect to the report of commission submitted before the state of Mysore before passing the said ordinance, my lord. In para 9 and in para 13, my lord. In para 9, the Supreme Court has discussed that what were the question before the commissions and what was the answer. I'll just read the points, the issues before the backward commission, my lord. Traditionally, empathy for education on account of social and environmental condition or occupational handicaps, poverty and lack of education institution in rural area, living in inaccessible areas, lack of adequate educational aid.
Para 9. Para 9.
Para 9. In continuation to para 9, this is in middle of para 9 where 7 points.
Para 9 starts with the problem raised for.
Right, my lord. Absolutely right. This is the end of para 9. There are 7 points were given. The commission has given its report on these 7 points, my lord. The Supreme Court has dealt these 7 points in this judgment in detail, my lord, including there was also an issue that whether the backward class can be divided into backward and more backward. I'm not going into this aspect of the case. I'm limiting myself to the extent of reservation, my lord.
Yes.
Now, my lord, may kindly have paragraph 34, directly paragraph 34 of this judgment. My lord, have paragraph 34.
Yes.
The learned Advocate General has suggested the reservation of a large number of seats for the weaker section of the society would not affect either the depth or the efficiency of a scholarship at all. And in support of this argument, he has relied on the observation made by the Backward Class Commission that is found on complaint in observation made by the Backward Class Commission that is found in complaint in the state of Madras, Andhra, Travancore, Cochin, Mysore, where the system of recruiting candidates from the other backward class to the reserve quota has been in work for several decades. The committee further observed that the representatives of the upper class did not complain about any lack of efficiency in the offices recruited by reservation. This opinion, however, is plainly inconsistent with what is bound to be inevitable consequences of the reservation in higher university education. If admission to the professional and technical colleges is unduly liberalized, and it would be ideal to contend that the quality of our graduates will not suffer. That is not to say that the reservation should not be adopted. Reservation should and must be adopted to advance the prospects of the weaker section of society. But in providing for special measures, is in that behalf, care should be taken not to exclude admission to higher educational center to deserving and qualified candidate of other communities. Appointment contemplated by the Article 60. A special provision contemplated by Article 15(4), like reservation of post and appointment contemplated by Article 16(4), must be with reasonable limits. The interest of weaker section of society, which are a first charge on the state and center, to have to be adjusted with the interest of the community as a whole.
No, how did the Supreme Court decide that whether it should be 50 or 40 or
I'm just.
how did they come to this 50%?
I'm just coming.
You
to
just
this.
come to that.
It's there only in this paragraph. There are only two paragraphs, my lord, 34, 35, and the finding
Because
paragraph.
prior to this, there was no concept of 50%.
There was no concept of 50%.
How did they come to this conclusion?
I'm coming to this in this paragraph only. In last they have discussed, my lord. The adjustment of these competing claims is undoubtedly a difficult matter. But if under the guise of making a special provision a state reserve, particularly all seats available in the colleges, that clearly would be subverting the object of the Article 15(4). In this matter, again, we are reluctant to say definitely what would be the proper provision to make. Speaking generally and in a broad way, a special provision should be less than 50%. Here they have said, my lord, it should be less than 50%. How much less than 50% would depend upon the present prevailing circumstances in each case. In this particular case, it is remarkable that when the state issued its order on 10/7/1961, it is emphatically expressed its opinion that reservation of 68% recommended by the Naga Border Committee would not be in a larger interest of state. So in this paragraph, they have said it should be less than 60% to safeguard the interest, also to provide reservation and to check whether the merit is given adequate respect or not, my lord. Now, my lord, paragraph 35. My lord, have paragraph 35?
Yes. Yes.
In the starting line, my lord, submissions are recorded. The finding of the Supreme Court is in last 4 line, my lord. We have already noticed the 5th line from the bottom, my lord. We have already noticed that the impugned order in the present case has categorized the backward classes into
35 starts with
the petitioner contend that,
ah,
my lord, the 5th line from the bottom, my lord.
on the bottom. Yes.
We have already noticed that the impugned order in the present case has categorized the backward classes on the sole basis of caste, which in our opinion is not permitted by Article 15(4). And we have also held that the reservation of 68% made by the impugned order is clearly inconsistent with the concept of social provision authorized by Article 15(4). Therefore, it follows that the impugned order is a fraud on the constitutional power conferred on the state under Article 15(4). So in paragraph 34, Supreme Court said the reservation should be within 50%, not even 50%, within 50%. And then
No, they said less than 50.
less than 50%.
Then why did they arrive at 50%? Where is that?
Now, my lord, kindly come to para 37. My lord, in Balaji, my lord, Supreme Court has said it should be less than 50%. They have never said that it should be 50%. They said it should be less than 50%. The limit they have, the ceiling limit they have fixed as 50%. Paragraph 37, my lord, last 7 line. From the bottom, my lord, may kindly have last 7 line. If my lord may require, I can read the entire judgment. They have also discussed the Rangachari.
Last 7 lines.
My lord, there can be no doubt that constitutional maker assumed as they were entitled to, and while making adequate reservation under Article 16(4), care would be taken not to provide for unreasonable, excessive, extravagant reservation for that would by eliminating general competition in a large field and by creating a widespread dissatisfaction amongst the employee, materially affecting the efficiency. Therefore, like the special provision improperly made under Article 15.4, reservation made under Article 16.4 beyond the permissible limit and legitimate limit would be liable to be challenged as a fraud on the Constitution. In this connection, it is necessary to emphasize that Article 15.4, like Article 16.4, is an enabling provision and it does not impose an obligation, but merely leave it to the discretion of the appropriate government to take suitable action if necessary. The writ petitions were allowed by the Supreme Court, and Supreme Court said the ordinance issued by the state of Mysore providing 68% reservation is not as per the Constitution, my lord. In this judgment, for the very first time, Supreme Court has observed that reservation should be within 50%, below 50%, not even 50%. It should be less than 50%. This is the constitutional bench judgment by the strength of 5 judges, my lord.
So this subsequently in Indira Sane got 50%.
50%.
They said 50.
Supreme Court said ceiling is 50%. Balaji said ceiling is 50%. It should be less
Cannot
than
be
50%.
more than 50%.
More than 50%.
All right.
So they have interpreted Balaji that the intention in this judgment was the ceiling is 50%.
So Balaji did not say it cannot be more than 50%. It just said it should be less than
50%.
All right.
In fact, they have made it very clear that it should be less than, meaning thereby it cannot be more than 50%.
All right. Yes.
The Rangachari judgment, which is 62 judgment, my lord, which is, that relates to the reservation and promotion. So I'm not reading that judgment entirely, my lord. The Rangachari judgment was dealt by the Supreme Court in the case of N.M. Thomas, my lord. N.M. Thomas is another judgment by the constitutional bench by the strength of 7 judges, my lord. The N.M. Thomas is the basis on which the commissions has given their report, my lord. My learned senior Anshuman Singh has already read the commission's report. The basis for the report, the basis for the state to come up with the reservation is the observation given in N.M. Thomas, my lord.
That we have seen, yes.
In
What else? Any other?
N.M. Thomas, my lord, I just wanted to point out that N.M. Thomas was not the case of pure reservation under Article 16.4, my lord. The N.M. Thomas, prior to the constitutional 77 and 87th amendment, by which the 16.4A and 4B was added, there was no provision for reservation in promotion, my lord.
Yes.
For the very first time in Rangachari, and thereafter, and Rangachari said there cannot be reservation in promotion. Thereafter, N.M. Thomas said, no, there can be. Again,
No, we are not on that point.
I'm just saying that
We are not dealing with that.
yeah, I'm saying, my lord, the reliance on Thomas by the state is wrong, my lord, because Thomas has never dealt with the pure issue whether what should be the extent.
Yes.
Thomas was essentially dealing with the reservation and promotion, my lord.
Yes. Yes.
And even, my lord, in dealing with reservation and promotion, they have said that with respect to the carry forward rule, the reservation ceiling of 50% can be breached. So I just wanted to
Thomas decision is?
Thomas decision is 1976, volume 2, SCC 310.
Volume 2, SCC
310.
31.
0. My lord, may also note down the paragraph because this judgment is related to the reservation and promotion and carry forward rule. The reservation and promotion, my lord, in services is like a paramedical shape reservation where the post in the lower cadre is more and compared to the higher cadres, my lord. So Supreme Court has said, while applying the concept of carry forward, the rule of 50% can be breached.
All right. Yes. No, we need not go through this.
My lord.
Yes.
My lord, I have just asked about the cap of 50%, my lord. It is given in the Maratha judgment in para 396 and 397. If not, I'll just read those 2 paragraphs.
Oh, that we have seen.
My lord.
That we have seen. No, we just wanted to know that when was this first time introduced?
It was
That
introduced
was
in Balaji, my lord. First time in
no,
Balaji.
Balaji said it should be less than 50. But
My
it
lord.
should not be more than 50 was said
But
by,
why I wanted to refer Thomas, my lord, few paragraph of Thomas.
that was Indira Sawhney.
Because ultimately in Indira Sahni, Supreme Court has taken all issues.
There is no other decision between Balaji and Indira Sawhney.
There are around 14 judgments, my
No,
lord.
on this cap, 50% cap.
No, my lord, not the specific.
All right.
There are judgments with respect to reservation, but not to the extent of reservation.
Yes, yes.
Few judgments follows Balaji, few followed Thomas, my lord.
What else?
Now, my lord, may kindly have Indira Sahni, my lord, just two paragraph I wanted to refer, my lord.
Which para?
1992 Supplementary 3, SCC 217, my lord.
92 supplement 3.
3.
Page?
Page 217.
All right. Which para?
My lord, paragraph 804. The Supreme Court has formulated the issues. They have discussed Thomas, they have discussed Rangachari. They have,
804 and?
my lord, I wanted to refer part 5 of the judgment. Question number 6. Answer to question number 6. Start from paragraph 804 to paragraph 816, my lord. Sorry, 818. To paragraph 818. Paragraph
804 to 818.
818.
Yeah, all these have been read over by Mr. Singh.
I'm not repeating any of them. I'm just saying the question which was formulated by the Supreme Court was that to what extent can reservation be made? This is question number 6. Whether the 50% rule enumerated in Balaji, a binding rule or a rule of caution or a rule of prudence. So Supreme Court has dealt with the cap of reservation and extent of reservation in this very judgment, Indira Sahni, my lord.
All right.
And my lord have already read. I'm not reading again para 8110, which said it should be 50%.
Yes, yes.
But there are certain exceptions, my lord. Now, my lord, one more fact, my lord. As far as the reservation and promotion is concerned, Supreme Court in Indira Sahni has dealt with this judgment of Thomas. And Supreme Court said the Thomas judgment is not a good law. There cannot be no reservation in promotion.
Yes, yes.
This is question number 7, paragraph 819.
Question number 7.
Page 819.
That relates to?
That relates to reservation and promotion, specifically dealing with the judgment of Thompson, my lord. 1997 judgment, which was relied by the state. And
How is it relevant here?
my lord, it's relevant because the reliance placed by the state on this judgment was watered down by the Supreme Court in Indira Sahni. In Supreme Court, in Indira Sahni has said, Thomas is not good law. There cannot be no reservation in promotion.
Yes, yes.
Now,
that we have heard.
my lord.
Yes.
I'm not reading all those paragraphs. Now, my lord, thereafter, in 2006, my lord, the two articles were added in the Constitution, my lord. Article 16, 4A and 4B by 77th Amendment and 85th Amendment. 4A is with respect to reservation and promotion, and 4B is with respect to carry forward rule, my lord. So these articles were added. These articles were added in view of the observation given by the Supreme Court in Indira Sahni, just to say that Indira Sahni is not operative, my lord. Now, my lord, may kindly have M. Nagaraj judgment in which the validity of these two articles were challenged, my lord. 2006 volume 8 SCC 212, my lord.
2006 volume
8 SCC 212.
Try to finish today.
Within 10 minutes, my lord. Because I will not repeat, I will not read again what is already read, my lord. I'm referring to paragraph
today, but I hope you remember that we are not here till 4:30.
Yes, 3:30, before 3:30.
Not 3:30, 3:15.
My lord.
All right. 2006 volume 8
SCC 212.
212.
This is M. Nagaraj, my lord. In this case, the writ under Article 32 was filed before the Supreme Court, challenging the validity of Article 16, 4A and 4B, my lord. I'll just read the fact of the case. Paragraph 2. The fact in the above writ petition, which is lead petitions, are follows. The petitioner has invoked Article 32 of the Constitution of India for a writ in the nature of certiorari to quash the Constitution 85th Amendment Act 2001, inserting Article 16(4)(a) of the Constitution retrospectively from 17/6/1995, providing reservation in promotion with consequential seniority as being unconstitutional and violative of the basic structure. According to petitioner, the impugned amendment reverses the decision of this honorable court in Union of India, Birpal Singh Chauhan, Ajit Singh, State of Punjab, Ajit Singh 2, Ajit Singh 3, Indra Sahni, and M.G. Bandyopadhyay. The petitioner say that the parliament has appropriated the judicial power to itself and has acted as an appellate authority by reserving the judicial pronouncement of this court by the use of power of amendment as done by the impugned amendment, and therefore violative of the basic structure of the Constitution. So this was the issue before the Supreme Court, my lord, in the case of M. Nagaraj.
Which para did you read?
This paragraph 2, my lord, the fact of the case, paragraph 2.
2.
Writ under Article 32 was filed challenging these constitutional amendments. Now, my lord, in M. Nagaraj, the relevant para 82 and 83, my lord, which talks about the limit of reservation, my lord. If my lord may permit me, I'll just read these two paragraphs.
They've been read, I think.
If my lord, then I will not read it again, my lord. Ultimately, my lord, the Supreme Court in paragraph 123 in this judgment, my lord, has said that the ceiling limit is 50% and it cannot be breached. And for providing reservation, there has to be a compelling reason. And for that, the state is required to collect data with respect to backwardness, adequacy of representation, and efficiency of service, my lord. In these three aspects, the state has to collect the data to provide reservation. And 16(4)(a) and 4(b) are only enabling provision. State has no right to provide reservation. Whenever they want to provide reservation, they have to collect a data to give effect to the enabling provision, my lord. If my lord may permit me, I'll just read the concluding paragraph 123. Because, my lord, I will be dealing with the voluminous report filed by my learned friend. And 123.
You will be reading that?
I will not be reading that, my lord. From the words, I
God.
will conclude it within 5 minutes, this report. The entire 4,000 page, my lord.
All right.
My lord, paragraph 123 of M. Nagaraj.
Yes.
However, in this case, as stated above, the main issue concerning the extent of reservation, in this regard, the state concerned will have to show in each case the existence of compelling reason. These lines are very important. In each case, the existence of compelling reason, namely backwardness, inadequacy of representation, and overall administrative efficiency before making provision for reservation. So reservation cannot be provided as a matter of right. Whenever the state wants to make provision, they have to show these compelling reason in each case, my lord. It cannot be a general provision that I have conducted a survey and therefore we are providing reservation. In each case, whenever they want to come up with some notification exceeding the limit, they'll have to provide justification with respect to these three cases in each and every recruitment, in each and every reservation, my lord.
Yes.
As stated above, the impugned provision is an enabling provision. The state is not bound to make reservation for SC/STs in a matter of promotion. However, if they wish to exercise their discretion and make such provision, the state has to collect quantifiable data showing backwardness of the class, inadequacy of representation of that class in public employment, in addition to compliance with Article 335, my lord, which talks about the administrative efficiency.
Yes.
It is made clear that even if the state has compelling reasons, as stated above, the state will have to see that its reservation provision does not lead to excessiveness so as to breach the ceiling limit of 50% or obligate to the creamy layer or to extend the reservation indefinitely. So, my lord, even if state has these compelling reasons to provide reservation, then also, my lord, the precaution has to be taken that it should not reach the ceiling limit. So in this judgment also, Supreme Court said the ceiling is 50.
Yes.
Except Thomas, my lord, which talks about the reservation in promotion, which was watered down by the Supreme Court in Indra Sahni, my lord. There's not even a single judgment which says that the ceiling limit can be breached, my lord. Even in Thomas, the Supreme Court has not said that it can be breached beyond 50%. So Supreme Court said, while giving promotion, reservation in promotion, the ceiling limit can be breached applying the carry forward rule. In Thomas, my lord, Supreme Court was dealing with a completely different proposition.
Yes.
Direct reservation by direct.
Yes.
Now, my lord, as far as the report is concerned, my lord, the Supreme Court in Pavitra 1, my lord, which is 2017, volume 4, SCC 620,
17.
volume 4,
Hmm.
SCC 620,
620.
620.
What is there in that?
My lord, in this case, the government of Karnataka, they have provided reservation, showing that there were compelling reasons to provide reservation. I'll just read one paragraph where Supreme Court has dealt with the similar type of studies. It's 2017, volume 4, my lord.
पढ़िए.
My lord.
पढ़िए.
My lord. In this case, my lord, the High Court of Karnataka, my lord, they have allowed these reservation. They have upheld the validity of ordinance providing reservation, and the matter was traveled to Supreme Court, and Supreme Court in Para 9 dealt with the decision of High Court. In Para 9, my lord, the High Court, referring to this court's judgment in M. Nagaraj, observed that the concept of catch-up rule and consequential seniority are judicially evolved concept to control the effect of reservation. Deleting the said rule cannot by itself be in conflict with equality code under the Constitution. The 85th Amendment gave freedom to the state to provide reservation in promotion with consequential seniority. Under Article 16(4)(a), if backwardness, inadequacy of representation, and overall efficiency so warranted, there is no fixed yardstick to identify and measure the above three factors. If the state failed to identify and measure the above three factors, the reservation can be invalid. Examining whether the state had in fact measured the above factors, the High Court observed that the order dated 27/4/1978 was issued by the state of Karnataka after considering the statistic available about the representation of SC/ST in promotional vacancies. On 3/2/1999, the policy was modified to limit reservation in promotion in cadre up to inclusive of the lowest category of Group A post, in which there is no element of recruitment beyond 66%. The order, which was further amended in 1999 to the effect that reservation and promotion of SC/ST will be continued to operate till the representation reach 15% or 3% respectively, and promotion of SC/ST and against the backlog was to continue as per the order dated 1997. Till the said percentage was so reached in the total working strength as per the Karnataka Scheduled Caste, Scheduled Tribe and other backward classes Reservation Act 1994, seniority in lower cadre is maintained in promotional post for the person promoted on one occasion. Since reservation has not exceeded 15% and 3% for SC/ST, while population of the said category has increased, there was adequate consideration for the above three factors of backwardness, inadequacy of representation, and overall efficiency. Section 3 of the Act provides for an inbuilt mechanism for providing reservation and promotion to the extent of 15% and 3% respectively for SC/ST. The state government collects statistics every year. The High Court held that the contention that if all the posts in higher chaos may be filled by SC/ST, the promotional prospect of general merit candidate will be choked and blocked and could not be accepted as a reservation promotion was provided only up to the cadre of assistant executive engineer. My lord, in this case, my lord, I just wanted to refer 3 lines, my lord. My lord, may kindly have, since the reservation, this is 17th line from the top, since the reservation has not exceeded 15% and 3% of SC/ST, while population of said category has increased, there was adequate consideration for above three factors of backwardness, inadequacy of representation, and overall efficiency, my lord. the state of Karnataka said we are not able to provide them adequate representation in state services, but their population is increasing. So therefore, these three factors are present and they need reservation, my lord. In this judgment, Supreme Court has said no, the reservation cannot be provided, my lord. Lord, I'm not reading the entire finding because this finding is basically based on the reservation in promotion. In paragraph 21, again, Supreme Court has dealt with M. Nagaraj judgment and various tests laid down by the M. Nagaraj. I'll just read the concluding paragraph, paragraph 30, my lord. In view of the above, we allow these appeals, set aside the impugned judgment and declare the provision of impugned act to the extent of doing away with the catch-up and rule and providing consequential seniority under section 3 and 4 to person belonging to SC/ST on promotion against the roster point to be ultra vires to article 14 and 16 of the Constitution of India. So these appeals were allowed, my lord. Thereafter, in 2019, my lord, Pavitra 2 came, my lord. In Pavitra 2, Supreme Court has allowed the reservation because the state has conducted the exercise as per the direction given in Pavitra 1, my lord. I'll just refer one paragraph from Pavitra 2. This is 2019, volume 16, SCC 129. The relevant paragraph is paragraph 108, my lord.
Para? Which para?
The paragraph is 108, my lord.
$108.
My lord.
This was that
My lord, sorry, 153, the concluding paragraph, sorry. This was the discussion. In concluding paragraph, why Supreme Court has accepted reservation. I just wanted to point out that. 153. For the above reason, we have come to the conclusion that the challenge to the constitutional validity of the Reservation Act 2018 is lacking in substance. Following the decision in BK Pavitra, the state government duly carried out the exercise of collecting and analyzing data on the compelling factor and adverted by the constitutional bench in Nagaraj. The Reservation Act of 2018 has cured the deficiency which was noticed by BK Pavitra 1 in respect of Reservation Act 2002. The Reservation Act 2018 does not amount to absorption of judicial power by the state legislature and Nagaraj and Journal complaints. The Reservation Act 2018 is valid exercise of enabling power conferred by the Article 16(4)(a). So Supreme Court in Pavitra 2 said we are upholding because they have conducted the exercise as directed by us in 2017 in Pavitra 1. Now, my lord, thereafter, my lord, I am not reading the Maratha judgment because my lord have already dealt with Maratha judgment in detail. The private petitioner, my lord, who are supporting the OBC reservation, my lord, they have filed a compilation. I will also not going into the details of the return filed by the state because my learned senior has already apprised my lord about the details. And my lord, the issue in Pavitra, my lord, is confined to only to promotion, not the direct recruitment, my lord. They are only concerned with 16(4)(a) and 4(v).
Yes.
Because one of the stand taken by the state is Pavitra 2 has allowed the exercise.
All right.
And why Pavitra 2 has allowed the exercise, my lord, I've read the relevant paragraph because the direction given in Pavitra 1 was followed. Now, my lord, with respect to the compilation filed by the private petitioner, my lord, in the present case, the 4,000-page compilation, my lord. In this compilation, I'm only going by the index. If my lord may have a compilation, my lord can see from the index. There's no need to go in detail, my lord. The compilation.
Yes.
My lord, in the compilation, my lord, the first document which they have filed, my lord, may kindly have the index of the compilation. The first document, my lord, they have filed is the memorial address to the Education Commission, a statement of information and education commissioner by Jitro Govindrao Pole, dated 19/10/1982.
Which compilation?
Heavy compilation filed by the private petitioner. It's around.
No, that we don't have. That is the report, Mahajan report.
Not Mahajan.
Mahajan Commission.
They
What
have
is
tried-
that?
In this compilation, my lord, I'll just briefly sum up, my lord. In this compilation, my lord, they have submitted various reports, including the Mandal Commission report, speech given by the Dr. Bhimrao Ambedkar in the Parliament, my lord, with respect to reservation, and other reports, my lord. All the reports, they are in 1980, 1990, and the latest is Ashwini Deshpande article of 2011, November 2011, which talks about the reservation in railways. There is an article written by one Ashwini Deshpande of 2011. Except this document of 2011.
So let them cover that. Let them speak about that report.
I will.
Whoever has filed that document, we've not seen it yet.
Malo, I just wanted to submit that such type of commission's report and such type of data will not satisfy the test as laid down by the Supreme Court and M. Nagaraj, followed by the other judgment, including the Maratha reservation.
All right.
So, my lord, the impugned act, my lord, is not in consistence with the Constitution, my lord.
All right.
That's it, my lord.
Yes.
Now, there is one more petition, my lord. I'm appearing in that petition also. WP 25972 of 21.
2597 of
21, my lord.
21. All right. Yes. Who else wants to argue?
There are few issues probably which has not been argued. On those issues, if Lordship permits one. But the time, as Lordship is direct, my lord, it is.
No, which point?
My lord, we are on the ground that, my lord, the legislation, if Lordships are kind enough to see, my lord, this is. Right from the statement of object and the reason for bringing that.
This no, whatever you want to submit is not
No,
covered
it
by
is
Mr. Anshuman
No,
Singh.
my lord, it is not. It's a different
Not.
angle, my lord, which is there. WP wants you.
Yeah, he has left something.
My lord. My lord, so I appear in WP numbers.
He might feel offended.
My lords. My lords?
He might feel offended.
No, my lord. He has exhaustively covered everything, my lord. Probably this thing has been left out for me to show to your lordship.
No, just give us shortly what do you want to.
My lords, if lordship sees, my lord, the reasons, my lord, the reasons given for bringing the amendment, my lord, why they want to extend it from 14 to 27%, my lord. The statement of objects and reasons, my lord. We start from that, my lord. If lordship sees, my lord, what I have just forwarded, the other backward classes are 27% of the total population of Madhya Pradesh. This category is socially and financially backward. The state government has prepared some schemes for upliftment of these categories. Even then, the said categories could not be socially and financially uplifted. Now, my lord, they have filed a return, but nowhere they have brought forward that what other efforts were made by them to uplift them, and why only they want to breach that 50% mark by saying that the schemes were not implemented. We say that there were no schemes which were brought forward. The state failed in its functions and duties to bring those schemes. In fact, a 1983 report, the Mahajan Commission report on which they heavily relied, also does not speak about what schemes the state had put forward to the oppressed persons or to the backward class persons, both socially as well as economically, for upliftment, my lord, and so that they can be come at par with the mainstream. My lord, for this, my lord, the statements and object, my lord, I rely on a judgment that how important these schemes are. 2013, volume 1, my lords. Volume 1, SCC, page 745, my lord. Namit Sharma versus Union of India would rely on para 21, my lords. Wherein they say 21. My lord, they say that in order to examine the constitutionality or otherwise of a statute or any of its provision, one of the most relevant consideration is the object and reason, as well as the legislative history of the statute. It would help the court in arriving at a more objective and just approach. It would be necessary for the court to examine the reason of enactment of a particular provision so as to find out its ultimate impact vis-a-vis the constitutional provision. Therefore, we must examine the contemplations led to enhancement of the act. My lord, this was with that reference, but the ratio is that the reasons given, the objects are very important, my lord, and here they give an object as defined by them in the act, is that they have taken various measures for upliftment of this category. Even then the said category could not be socially and financially uplifted. Their report also, the 83, my lord, the Mahajan Commission reports also does not speak about what efforts were taken, nor in their return they say that these are the efforts which were taken by them and these have failed because of these reasons or because of any other reason. So they have, in fact, my lord, no reasons and no efforts were made to breach that marks. And they say that these are the exceptional circumstances cases which would help them in crossing that barrier of 50% mark, my lord, as has been.
No, if it is the failure of the government
My lord,
to bring them to
my lord,
to whatever level the government is wanting to bring,
my lord.
so can that be a ground for not providing that reservation?
No, what we, no, not provide, no, my lord.
It
The
is a failure of the government.
we say that
But
for
ultimately,
failure,
they are continuing to suffer.
no, for that failure, we say, my lord, they cannot extend it, considering it to be an exceptional circumstances to breach that 50% mark.
Yes.
My lords, if lordships, though Mr. Singh has already read Maratha reservation, my lord, but with regard to this, there are two conclusions also in those Maratha reservation, my lord. The conclusion would be in paragraph number 688.4 and 688.5, my lord. My lord, it says, my lord,
Mara?
688.4, my lord, and 688.5.
Citation?
The Maratha reservation, my lord.
Citation?
Citation is 2021, volume 8 SCC, my lord. Would start from page number 1 onwards.
1.
My lord.
Which para?
Para, my lords, on page number 324 of the para, 688.4.
No, para.
Para, my lord, that is the conclusion part. It has been written as 688.4.
3?
688.4.
688.
0.4, my lords.
1.4. Yes.
They say that the providing reservation for advancement of any socially and educationally backward classes in public service is not the only means and method for improving the welfare of a backward class. The state ought to bring other measures, including providing education facilities to the members of the backward class free of cost, giving concession in fees, providing opportunities for skill development to enable the candidate from the backward class to be self-reliant. And the next para also, my lord. There can be no quarrel that the society changes, law changes, people changes. But that does not mean that something which is good and proven to be beneficial in maintaining equality in the society should also be changed in the name of the change alone. So this is, my lord, with reference to the law laid down in Indra Sahni's and other cases, my lord. Now, my lord, there is another aspect, my lord. If lordship could see page number para 406 of this judgment, my lord. 405 onwards, my lord. The constitutional measures of providing reservation, giving concession and other benefits to the backward classes, including socially and educationally backward classes, are all affirmative measures.
407.
405 onwards, my lord. इसी का 405 and 406, my lord. The constitutional measures of providing reservation, giving concession and other benefits to the backward classes, including socially and educationally backward class, are all affirmative measures. We have completed more than 73 years of independence. Maharashtra is one of the developed state in the country which has the highest share in the country's GST, that is 16%, higher share in direct taxes, 38%, so and so. Contribute to country's GDP, so and so. The goal of the constitution farmers were to bring a casteless society, to promote welfare of the people by securing and protecting as efficiently all the institution of the national life, providing reservation for advancement of any society, socially and educationally backward class in public services is not the only measures and method for improving the welfare of the. Now,
Yes.
my lord, 406, my lord, what they have quoted, Justice Ravindran, my lord, I would like to quote. 406 पैरा का जो कोट किया है उनने वो caste has divided this country for ages. It has hampered its growth. To have a casteless society will be realization of a noble dream. To start with the effect of reservation may appear to be perpetuate caste. The immediate effect of caste-based reservation has been rather unfortunate. In the pre-reservation era, people wanted to get rid of backward tag, either socially or economically. But post-reservation, there is a tendency even among those who are considered as forward to seek the backward tag in the hope of enjoying the benefits of reservation. When more and more people aspire for backwardness instead of forwardness, the country is itself stagnates. Be that as it may, reservation as an affirmative action is required only for a limited period to bring forward the social and educationally backward class by giving them a gentle supportive push. But if there is no review after a reasonable period, and if reservation is continued, the country will become a caste divided society permanently instead of developing a united society with diversity. We will end up as a fractured society, whatever suspicion of each other. While affirmative discrimination is a road to equality, care should be taken that the road does not become a rut in which the vehicle of progress gets entangled and stuck. Any provision for reservation is temporary clutches. Such clutches by unnecessary prolonged use should not become a permanent liability. It signifies that Constitution does not specifically prescribe a casteless society, nor tries to abolish the caste, but barring discrimination in the name of caste and by providing for affirmative action, the Constitution seeks to remove the difference in status on basis of caste. When the difference in status among caste are removed, all castes will be equal. That will be a beginning of for a caste.
Mr. Pandit, this reservation,
My lord.
so far as reservation of seats in the Legislative Assembly of Parliament, I think it was introduced for a
limited period.
limited, that was 10 years and it has been extended every time.
Extended time.
But there is no such, nothing can be read in 16.4 or to mean that it was temporary.
Manus, but if Lordship sees now what they have introduced, no, for that it has not been that it is temporary, my lord. The article does not say so. But the framers of the constitution was well aware that this thing can be used politically for being popular in the society, my lord. And therefore there was a limit for reservation.
So where is that 10-year limit?
It was initially, my lord, it has come from the debates, my lord, which were there. So that it would be 10 years only for that. So, my lord, what we say is that their inability or failure to implement these other schemes, my lord, for welfare, they cannot extend this to 50%, which has been held to be a benchmark, that they cannot exceed 50%.
Yes.
My lord. And the aims and objects, my lord, I have given on which basis they say. In fact, my lord, they say that there are 27% of backward percentage population. In their return, the figures are different. And in the committee's report, the figures are different. So we say that there is no nexus between the law which they have made on the basis of reports or any other thing. It's just that they wanted to bring a law and they have brought the law for being popular in this.
So that 10 years, I think, is there in part 16.
My lord.
Reservation of seats for SC/ST in the House of the People,
My lord.
Lok Sabha.
So this aspect was, my lord, probably another aspect which was there.
Please.
My lords.
That's all.
Yes.
Yeah. Anybody else?
I am for petitioner in 3 writ petitions, my lord.
Hmm.
Serial number 30.
No, Mr. Pandit, you are in which petitions?
In item number 37.
How many
8,
cases?
13 and 20, my lord.
No, just give us the
37.8.
no WP number.
WP number is, my lord, 25341 of 19,
341 of 90,
4523
45,
23 of 2020, and 8378 of 2020,
8378
my lords.
of
8378 of 20, my lords.
3 petitions.
3 petitions.
All right. Yes.
I am for serial number 37.10, my lord. There is a WP number 3757/20.
Are you adopting or you want to argue separately?
Some other fact is brought on the knowledge of this honorable court, my lord, before I will submit it. Because I have challenges the two issue.
So
Number one,
then we'll start tomorrow then
Hello.
with you because it's almost 3:12. हाँ बताइए.
So my presence may be marked let's see the WP number 25972. SM group connecting. I adopt the arguments of the SM group. Lordship.
आपका कौन सा नंबर?
उन्होंने मार्क प्रेजेंस मार्क कराया है इसमें 25972.
किसमें आपका क्या नंबर क्या है WP का?
WP number 25972 2000.
हाँ वो तो उन्होंने बोल दिया.
Yes, Lord.
That we have noted.
Along with RS Seni.
Along with
RS Seni advocate. Ravi Shankar Seni advocate.
वो that the reader will see that. आपका power अगर होगा तो.
Yes, power.
ठीक.